go back and look at the notes we just took about what we heard here, it was nothing we didn't expect to hear today. So we've prepared a preliminary complaint, and barring anything unusual, we could file as soon as tomorrow.
Okay, you're filing the lawsuit. What are you contending?
The controlling board does not have the authority to act as a legislator. That's Revised Code 12717. If it did have that authority, it would be unconstitutional. It would violate Ohio's Constitution, Article 2, which requires that general laws be made by the legislature. And that issue has been considered before by the Ohio Supreme Court, and the court's consistently come out on our side. And we would expect and hope that the court has the courage to do that again here on this much bigger case, albeit than some of the past ones.
So this is something that will be filed at the Ohio Supreme Court?
Most likely.
Don't you? They've ruled on this before, on the controlling board appropriating money. There have been other suits that have gone through and back in many years, and they really haven't had much success with them. So,
what the Ohio Supreme Court said very clearly in 1983 is that the controlling board is only constitutional at all because of Revised Code 12717, which requires the controlling board to vote consistent with the acts of the General Assembly. The act of the General Assembly in the budget bill was very clear. It was a prohibition on Medicaid expansion and an appropriation of federal funds. Now that act was line itemed by the governor. However, the governor's line item isn't relevant to the act of the General Assembly alone, which was to prohibit the receipt of these federal funds that today the controlling board accepted.
So you'll be suing on behalf of whom?
We'll disclose that tomorrow.
Do you expect that House lawmakers will be a part of the suit?
Most likely.
And you expect to file it tomorrow?
Most likely.
What would prohibit you from doing that?
We're going to go home and review the notes here and make sure that nothing has changed. It did not sound to me over the last 2 hours like anything has changed. So I can't think of anything, but obviously there are a lot of unusual political overtones here that usually don't affect our cases, and those could be in play.
So if your suit proves to be successful, what do you say to the 366,000 Ohioans that won't be eligible for Medicaid?
Well, what this lawsuit would mean is nothing about whether those Ohioans would be eligible for Medicaid or some other kind of health care. Our litigation is strictly about the separation of powers and checks and balances in Ohio, and it's perfectly acceptable if the legislature could go back to the drawing board and work out something with the governor. In fact, our organization has been very vocal on Medicaid expansion as a policy issue itself, and we think that it's a bigger issue that the controlling board not have unlimited authority than the Medicaid expansion either happen or not happen in Ohio. So that's really where our focus is.
So are you going to be asking for a temporary injunction on the on the appropriations? You will be.
Sort of. There's a different name for what we're looking at, but that's sort of correct. As you all know, the decision has to be made by January 1st, 2014. So we're on a really short track here. We're basically on a 10-week track to decide this up or down. If it lingers on beyond then, the expansion obviously is going to happen.
How do you respond to the argument that because this was vetoed and didn't become law, that's not legislatively taxed?
Sure. The Revised Code 12717 specifically says the controlling board must act consistent with the intentions of the General Assembly. The General Assembly does not include the governor.
The fact that it was vetoed by whom has nothing to do with
Right. It has no bearing on the intentions of the General Assembly. Obviously, it has a bearing on what the law is today. And usually, the law and the intentions of the General Assembly will be synonymous. So it's very unusual to have this kind of a law, but it's necessary to have this kind of a law focus on the intention of the General Assembly in order to render the delegation of legislative authority to the controlling board constitutional at all. And that's what the Ohio Supreme Court has actually said.
Since it's not a temporary injunction, can you help us out and tell us what it is?
Yes.
Sure, it's a writ of mandamus and prohibition.
But would it just be about accepting the money, or would it be about expansion more broadly?
One of the issues is the controlling board's actions today.
Yeah.
There is another legal issue that relates to something that you heard about inside here, and that has to do with the state plan amendment that was proposed by the director of Medicaid,
so you're challenging
which is also a very recent development, and you'll kind of see how those two interplay about this time tomorrow.
So you would be challenging the whole thing then? as far as your written mandatement?
Yes, we will not put in quotes when we file it, but yes.
Coming in late, if you could again just tell us your next step at this point.
We're looking at legal action related to the law authorizing the controlling board. Revised Code 12717 requires the board to act consistent with the intentions of the General Assembly, and the General Assembly's budget bill explicitly prohibits the receipt of federal funding that today the controlling board received for the expanded ACA Affordable Care Act population, which is up to 138% of poverty level.
And you will be going to court tomorrow, is that what?
We hope so.
So as we heard today, this decision will last through the biennium.
Right.
If you're successful, that decision will last past the biennium into the future.
Well, this is an important question. Success for us looks like the Ohio Supreme Court simply reminding the controlling board of its limited authority. It does nothing to prohibit the future expansion of Medicaid, the retraction of Medicaid, as you heard today, or any other kind of Medicaid policy. All we're indicating is that that kind of decision cannot be made by these 7 people sitting at this chair today. As one of the members pointed out, in a very truncated hearing where really this should be done before, this should be done before the General Assembly, very deliberately, with a number of witnesses and testimony, and what we saw was kind of a makeshift attempt at reproducing what the General Assembly can do so much better and representing all Ohioans instead of the very limited number of Ohioans who are represented in that room today. So this really is about administrative largesse and administrative overreach. And the Ohio Supreme Court does make it clear the controlling board is an administrative agency. It's not a super legislature.
So as we've heard before, the Ohio Supreme Court has made rulings for the legislature on school funding. And the legislature has basically said, thanks for the suggestion,
Right.
We're going to do what we want to do. Does this also apply to your court case? In other words, going forward, could they come back and do this at the start of the next biennium?
No prediction whatsoever as to what might happen in the legislature or even in the court for that matter. We think we have a strong legal argument, but no idea how the court will handle it.
Okay, Maurice,